In order to prove that, you have to prove two things. You have to prove that there was not probable cause for the arrest and that the arrest was actually done in retaliation for that protected activity. We are the Armed Attorneys. Today we're talking about a widely reported and misreported case that came out of the Fifth Circuit regarding open carry. We're going to talk about whether or not your right to open carry has changed. We're going to talk about what happened in this case, and we're going to talk about whether or not this could affect any part of the law in the rest of the country. But before we get started, show your support for the Second Amendment by hitting the like button. And stay tuned, we have a gigantic giveaway from one of our favorite sponsors, Vanish. It's coming a little later on. We'll give you the details. Stick around.
Now, as a little bit of background, this is a Texas case, but I think it's instructive for everybody to kind of have an idea about, just to see how attacks on the Second Amendment can come in kind of unusual forms. And on the back of this, we're looking at a Texas case called State v. Ross. It's a 2019 case, and it looks at our disorderly conduct statute. And so we look back at Texas's law on carrying long guns, and really they're kind of unregulated under Texas law. Besides our list of statutorily prohibited places, we look at, hey, how do we carry long guns in public? And our courts have said, hey, as long as you don't carry them in a manner calculated to alarm, you can carry long guns in public generally. Now we have this 2019 case that kind of narrows that a little bit and makes it a little bit more dicey.
Yes. So before 2019, and I will tell you that Mr. Edwin Walker and I tried a disorderly conduct case together out in Beaumont, Texas, before this 2019 case came down. And we spoke to a jury and we convinced them that our client did not, in fact, carry his rifle in a manner calculated to alarm, because the standard at that point was, in his mind, did he make a intentional calculation to alarm people? And the answer was absolutely not. Then 2019 happens, State versus Ross happens, and the Court of Criminal Appeals in Texas changes the standard and says, actually, it's not what's in the mind of the defendant, it's whether or not a reasonable person would have become alarmed. Under that circumstance, I may have lost that case, by the way.
Yeah, we see those are two big different things. Hey, I didn't intend to scare people. Well, you're never going to prove that crime. So I guess the state comes in and they change it to say, hey, would a reasonable person be alarmed? Well, that's a kind of a slippery slope, especially with quickly changing opinions about firearms.
Yes.
And so there's really no limiting principle, I would say, on that law. And hopefully it gets addressed. Obviously, this is something that we're going to be lobbying against. This is a bad law. It's something that we need to have fixed and some clarification on. We'll get to work on that. But it brings up this kind of new case that happened near San Antonio that just got heard out of the Fifth Circuit Court of Appeals. Between the two of us, we have tried out a lot of different holsters, and the Vanish holster is by far one of the most comfortable we've ever used for everyday carry. With a 48-inch waist belt, the Vanish holster offers a perfect fit for every body. The adjustable belt is made of a durable polyester blend and ensures that sweat and moisture are seamlessly wicked away.
And let's talk about the weight and the bulk, or more realistically, the lack thereof. The Vanish holster weighs a mere 6 ounces, and because the pocket pulls the gun close to your body, there's almost no printing.
It features 2 utility or mag pouches, is ambidextrous, and has an enhanced non-penetrable trigger guard for maximum safety. However, whenever you need it, the magnetic closure allows for an easy thumb break.
This is the first time we've ever been sent a holster to try that we fought over. It's not the first holster we've been sent to try, but it was so fantastic. I actually went out and bought one for myself because Richard insisted that he got to keep the sample.
Our major giveaway is courtesy of Vanish holsters, and we're giving one of our viewers this incredible, fully customized Chevrolet Silverado Trail Boss Z71 worth $80,000 thanks to Vanish.
To enter, all you have to do is click the link in the description and purchase one of the most comfortable holsters you'll ever own, or your money back guaranteed. Or purchase a Vanish t-shirt and Vanish will get you hooked up. Get $50 off now when you use our link below, plus bonus entries with each purchase up until June 3rd. Get to it. Yeah, so this is Everard et al. Versus Valenciano. If you want to find it, it is 93 F 4th 903, published February 26th of 2024. It has been wildly and widely misreported as a ban on open carry in Texas. This is not that. Richard, what happened?
So this was a qualified immunity case.
This was a qualified immunity case.
And so to give a little bit of background of what happened, we have an organization in Texas. We have some Second Amendment advocates in this small town, open carrying. Cops get called. There's several 911 calls. Police go to investigate. kind of kerfuffle ensues, argument ensues over, people exercising their First Amendment rights, carrying, demonstrating in public, also exercising Second Amendment rights, carrying long guns in
Hmm.
public. They
Well, one long gun, one
One
handgun is
long
what
gun.
really is we're coming down to in the case. But yes.
Yes, they get arrested for a violation of this disorderly conduct.
Hmm.
Those cases were dismissed.
Yeah, so disorderly conduct, and then there was also an arrest for, I think, interfering, right?
Yeah,
Interfering with or obstructing. So those are all dismissed, though.
yeah, criminal cases go away. The folks involved in the demonstration, they sue the city of Alamos Park. They
Sue
sue
the
the
police chief,
officers, the
yeah.
police chief, and so they're filing what we call a Section 1983 claim. This is a deprivation of federal rights. This is where you say, we have this statute under federal law that says, hey, guess what? If the state governments violate your rights, county governments, municipal governments, then we're going to give you this statute. We're going to let you sue them, but there's some hurdles that they have to breach. But let's talk about the claims just a little bit.
Sure. So what actually gets left at the Fifth Circuit stage, because they failed to brief lots of what happened at the trial court. So what gets left at the Fifth Circuit stage is, I mean, that touches upon open carry, is really a retaliation claim.
Yeah,
So
that's
it's
the big one.
right. Essentially, the government cannot retaliate against you by arresting you for exercising your First Amendment right. Now, in order to prove that, you have to prove two things. You have to prove that there was not probable cause for the arrest and that the arrest was actually done in retaliation for that protected activity.
And it kind
And
of fails on both of those.
it fails on both of those. So that's why we have a discussion here of the standard of disorderly conduct, because the court did have to say, yes, there was probable cause for that arrest based upon disorderly conduct, based upon the open carry of firearms. But the Fifth Circuit didn't change a thing. The Fifth Circuit restated the law that has been the law for years as to, is disorderly conduct constitutional? In fact, big shout out Edwin Walker, because the Fifth Circuit relies heavily upon an as applied. No, it was not an as applied
Poe
challenge.
case.
Yeah, they rely quite a bit on a constitutional challenge that Edwin Walker made to the disorderly conduct statute years ago, that unfortunately failed because the Court of Appeals in Beaumont made a terrible decision about whether or not this was a constitutional statute, and then the Texas Court of Criminal Appeals didn't take that one up. Anyway, that all is awful news, but they are just restating what has been the law in Texas since 2016 and 2019, respectively. Nothing changed, and yet this is purported widely as some sort of huge restriction on
Open
open
carry.
carry, and it is not.
No, really, this is a qualified immunity case. The government has to agree, generally, has to agree to be sued. Guess what? Spoiler alert, they don't agree to be sued very often. And so then we look at this Section 1983 claim. We look at the hurdles that have to be overcome in order for the government to open themselves up by statute to lawsuits. And so we're looking at, hey, can I sue the government? I mean, really, what this comes down to is, can I sue the government for arrest arising out of this disorderly conduct incident? And the short answer is no.
Exactly right.
But ultimately, I mean, we have to ask the question, this happened in the Fifth Circuit Court of Appeals. Would this decision be replicated in other circuits? And does this, or could this, have an effect on open carry in other states? What do you say to folks?
Well, so first, I will start by just explicitly restating no one's open carry rights in Texas or the Fifth Circuit have changed. And all of the articles and all of the people saying they have are 100% wrong. Now, this is potentially a case that could be instructive to other circuits on retaliation, on qualified immunity. However,
Municipal liability?
municipal liability. However, I will say I sort of doubt that. And the reason for that is that the Fifth Circuit is notoriously unwilling to let anyone bring a 1983 claim.
Yeah, even like judges. Can't sue a
Yes,
judge.
no, if the government abuses your rights in Texas versus the government abuses your rights in Nebraska, you better hope you're in Nebraska, because the Fifth Circuit is the least like they have restricted 1983 in multiple ways that we do not see anywhere else in the country. So while possible that this could have an effect, not on open carry, but on 1983 claims and qualified immunity outside of the Fifth Circuit, it is possible that someone would take it as instructive and another circuit would make a decision, but very unlikely just given the nature of the Fifth Circuit and qualified immunity in 1983.
Yeah. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Until next time, we're the Armed Attorneys.